been years.
Good morning. How are you?
Are sharing links.
How are you? Yes.
There, okay, so let's take one more.
Yes. Yes. Password, so I remember it.
What I did.
Stand in between. I think you'd be an asset for both.
Yep. All right. Yeah. It's
You log in. So this is the username, password for internet access.
Oh, great. Thank you.
All right.
No, hold on, it's okay.
Great, good morning. Welcome to docket number 210701. The application of the Connecticut Light and Power Company and Yankee Gas Services Company, the United Illuminating Company, Connecticut Natural Gas Corporation, the Southern Connecticut Gas Company for approval of a
Sure. Thank you for the helpful recitation. You know, I want to respond to one specific statement you made, which is redo today. That's not what the motion is requesting. We're prepared to proceed today. We've produced our witnesses, and we believe we should proceed today. It's really just a matter of making sure that we comply with the UAPA. And I would say that at a minimum, all of the points that the chairman just made still do not, at least in my view, in all due respect, address the UAPA compliance issue, which is still, as of this morning, beyond the pre-file testimony, we have no notice about the specific evidence the authority is relying upon in the contested portion of this proceeding to reach a conclusion. And so, you know, at a minimum, what the company's motion is saying, that to comply with the UAPA, out of the vast record that we have in this uncontested proceeding, which was opened initially, it would be helpful if the authority could identify through a notice of taking administrative notice of what you plan to rely upon beyond the pre-file testimony.
I appreciate that. I'm going to try this one last time because I'm really having a difficult time reconciling that point with the concession from a few minutes ago that we agreed that the second prong under 1641 subsection C, which requires a short and plain statement of the matter asserted or charged. We agreed that the company is not disputing that the authority has satisfied its burden under that. And in fact, the NOV does contain attachments that are appended to it. It contains citations throughout the NOV. So if the authority is always bound by the substantial evidence test in that we have to have citations, appendices, citations to your pre-file testimony, I'm struggling to understand what the prejudice is that you're alleging, because I think that's what this boils down to. Am I missing something still?
I think if I can try to respond to the question again, what the principal thrust of the motion beyond just making sure we have an update to the notice of proceeding to confirm it is a contested case. I'm pleased that the chairman confirmed that this is a contested proceeding because we believe it is. And we think that one way to address it is to simply update your notice of proceeding to confirm it is a contested case, because right now we have that ambiguity. We have a notice of proceeding that is not consistent with the statements just made by the chair. You said it's a contested case. The notice of proceeding says uncontested. But the other issue would be, is the authority now providing clarification to the applicant that the only evidence being relied upon by the authority in reaching its decision would be just simply the information that's cited to in the notice of violation, because that's a helpful clarification, and the pre-file testimony that we submitted in this proceeding and today's hearing transcript.
Okay, I just want to back up a second. We agreed that the 1641 does not require a notice of proceeding to be issued. Do we not? There is a notice of proceeding in this case. I'll grant you that. I think what I was troubled by in your motion was I think the way it was characterized was a bit misleading in suggesting that the NOP had maybe just been issued and that we had made some kind of error in deeming it uncontested, when in fact the NOP was issued in the fall of 2021. And we have, in the dozen dockets that I cited, not issued an updated NOP when we then issued an NOV in those dockets. So I want to start there. But the second the second piece I would say is the second prong of that three-prong contested case is in fact that a hearing is statutorily required, and that the agency is in fact offering that opportunity and holding the hearing. So insofar as 1641 comports with that three-prong test, I would concede that it's contested. My point this morning is that it doesn't matter what the vice chairman says, what I say, what Commissioner Karen says in terms of whether a case is or isn't contested. The statute and the legal precedent governs, and if it's contested in accordance with the statute, it's contested, and if it's not, it's not. So I just want to kind of correct the record there and just make sure that we're on the same page. And I'll give you a moment to respond to that.
Well, I think the good news is, at least on the point that you mentioned, we're in agreement. And that is, I agree with the chairperson's recitation of the legal authority, which is that no individual can elect to call something contested or uncontested on their own volition. Instead, as the chair correctly points out, it's dictated by the legal precedent and legal authority. And I would agree that in this case, because 16-41D states that we can elect to have a hearing, which we have, in our view, that's dispositive, because 4-166 subsection 4 says a contested case includes a proceeding where a hearing is required by statute. So I agree with that portion of the chair's statements. And I would also point out that, again, what this comes back to is we have a notice of proceeding that's, at least for the record, if an appeal is taken, it's inconsistent with the discussion we had. And at least one request would be, is the authority amenable, and you can elect not to update the notice of proceeding. And then secondarily, it goes back to, in a contested case proceeding, the authority and the docket participants would need to comply with the Uniform Administrative Procedure Act. And the section I had referenced, which was 4-177C, says that in a contested case proceeding, any entity given party status has an opportunity to submit rebuttal testimony and conduct cross-examination on the record evidence the authority tends to rely upon in reaching its conclusion. And the question the motion really is posing is beyond the pre-file testimony and beyond the information specifically cited in the notice of violation. Is there any other record evidence from the underlying initial uncontested docket the authority tends to rely upon to reach its conclusion? If the answer is no, then I think that's very helpful, but that's the thrust. And thank you for the chance to offer clarification on the motion.
Thank you. I'm just going to ask a couple follow-up. Is the authority required to take administrative notice of its own prior decisions?
In a proceeding involving the imposition of a monetary penalty, like this proceeding on a public service company, where it is a contested case, and we have the right to offer rebuttal testimony, and we have the right to be able to conduct cross-examination, it's at least my position, and I realize the authority could disagree, it's my position that it should be clear in terms of what evidence is being offered, and especially if the decision being incorporated was an uncontested case, I would submit that it's not going to be binding because, and we can cite to the precedent in a supplemental proceeding, but there's a Connecticut appellate court decision referred to as Tiger Claw. We can provide the citation. That says that when an administrative agency issues a decision in an uncontested proceeding, it has no binding impact through res judicata or collateral estoppel because it's not been subjected to judicial review. And therefore, it could be offered as a piece of evidence, but it should be subject to cross-examination and rebuttal.
Okay, I think that may be inconsistent with the position that the company has taken in other proceedings. So I'll make sure to keep this in mind. But let me ask one other question, and then I think we can.
And Chair, I would say, I know that the authority says that may be inconsistent with positions that we've taken. What I would offer for the authority's consideration is, for example, when I was representing a different client in the Aquarion rate case, and I made reference to decisions in other rate cases, what I would note there would be that each of those prior rate cases, including the Connecticut water case, were decisions that were issued in contested proceedings that were subject to judicial review, and under the Tiger Claw analysis could then have impact in terms of being precedential. And so that would be the distinction I would offer. If the decisions the authority tends to rely upon are decisions in uncontested cases, according to the Tiger Claw decision, they would not have res judicata or collateral estoppel impact in future proceedings.
Okay, thank you. And then I think probably my last question is, keep coming back to the NOP, which I'm a bit confused by because I think we've agreed there's not an NOP requirement in 1641, but to the extent that we keep coming back to that and we're referring to the November 2021 NOP, which talks about being uncontested. And I take it that the company is invested in having that changed. And I'm not sure why, because the company has not, appealed decisions that the authority has marked as uncontested. So if that NOP says uncontested, and we agree that the legal precedent doesn't matter what the authority calls it, it is or it isn't contested under the statutory analysis. And we agree that your client has had the opportunity for pre-filed testimony and a notice for hearing. What is it about that NOP being changed from uncontested to contested that we're still hung up on?
I would just say that it's important to make sure that the record is updated to reflect the current procedural posture. I agree that, you know, if the authority were elect not to update the notice of proceeding, we would still take the position based on the reasons I mentioned that this is a contested proceeding and the authority is elected, which is within your authority to do that, to not update the notice of proceeding. But I still come back to me, that's more of a subsidiary issue. It's more of a housekeeping type issue. The real thrust of the motion, again, comes down to in a proceeding where an applicant is facing $200,000 in monetary fines and they have a right to a contested case proceeding, we're asking for just greater precision and clarity in terms of what evidence the authority is relying upon in the underlying docket. And I think that we've made progress in this colloquy, and thank you for the opportunity. That it sounds like, to my interpretation, that it's going to be the pre-filed testimony we submitted, which will be adopted under oath and subject to cross-examination today. It would be the transcript from today's hearing, which is under oath, and it'll be the information the authority relied upon in their notice of proceeding. And we'd respectfully submit for your consideration if there's additional record evidence that parties want the authority to rely upon, to avoid having the parties try to guess what that is, that they submit a motion for administrative notice that identifies what it is and the underlying record they're asking the authority to rely upon. And they may elect not to do that, which is their prerogative.
Thank you, Attorney Pace. I think you just made a slight misstep in that you referenced a notice of proceeding, and I think you meant notice of violation. I just want to make sure that that was what you meant.
The notice of proceeding still refers to this as an uncontested proceeding.
I apologize. And in your last statement, you said if you were recapping what you understood from me, and I think you had a slip of the tongue in referring to the notice of proceeding, and I want to make sure the record reflected that you were referring to the notice of violation. You summarized the evidence that you thought we were relying on, and you said today's pre-filed testimony, the transcript, the notice of violation, and the attachments there too. But you said notice of proceeding.
Thank you, Chair. I apologize for the misstatement, and you are correct. It is the evidence that's referred to in the notice of violation.
Okay. All right. I'm going to leave that there. I don't think we're going to rule from the bench today. So I'll take that under advisement, but I do appreciate the conversation this morning. So if there are no further administrative matters from the company or anyone else, then I think we will proceed with our agenda, which requires first the witnesses to be introduced before being sworn in, please.
Good morning. Our witnesses today are Ms. Jessica Kane, Mr. Daniel Trainer, Ms. Teresa Washington, and Ms. Megan Bernardini. So I'll go through one at a time. Oh, with your permission, I will now proceed to have the witnesses adopt their pre-filed testimony and exhibits.
A very good attorney here. I just need to swear them in very quickly. Oh, yeah, do this a little bit out of order. If the witnesses could please raise their right hand. I will administer the oath at the conclusion of the oath. If you can say, I do. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury. Thank you. Please proceed, Attorney O'Hare.
Okay, thank you. Ms. Kane, please identify your full name and title for the record.
Jessica Brahini. Thank you. Jessica Brahini Kane, Vice President of Customer Operations and Assistance Programs.
And did you also sponsor pre-filed testimony dated June 1st, 2023?
I did.
And was that pre-filed testimony prepared by you or under your direction and control?
It was.
And do you have any changes, corrections, or additions that you wish to make to your pre-filed testimony at this time?
I do not.
And do you adopt the pre-filed testimony and exhibits as your sworn testimony today?
I do.
Mr. Trainer, please identify your full name and title for the record.
Good morning. My name is Daniel Trainer. I'm the Director of Collections and Assistance Programs for Eversource Energy.
Thank you. And did you also sponsor pre-filed testimony file dated June 1st, 2023?
Yes, I did.
And was that pre-filed testimony prepared by you or under your direction and control?
Yes, it was.
And do you have any changes, corrections, or additions that you would wish to make to your pre-filed testimony or exhibits at this time?
I do not.
And do you adopt your pre-filed testimony and exhibits as your sworn testimony today?
Yes, I do.
Thank you. Ms. Washington, please identify your full name and title for the record.
Teresa Washington, Manager of our Credit Hardship Programs and Protections.
And did you also sponsor pre-filed testimony and exhibits dated on June 1st, 2023?
Yes, I did.
And was that pre-filed testimony and exhibits prepared by you or under your direction and control?
Yes.
And do you have any changes, corrections, or additions that you wish to make today?
No.
And do you adopt the pre-filed testimony and exhibits as your sworn testimony today?
Yes.
Thank you. Ms. Bernadini, please identify your full name and title for the record.
Megan Bernadini, the Director of Customer Communications.
And did you sponsor pre-filed testimony and exhibits dated on June 1st, 2023?
Yes, I did.
And was that prepared by you or under your direction and control?
Yes, it was.
And do you have any changes, corrections, or additions that you wish to make today?
No, I do not.
And do you adopt the pre-filed testimony and exhibits as your sworn testimony today?
Yes, I do.
Chairman Gullett, the Eversource witnesses have now been sworn in, and now Ms. Kane is available to give the opening statement.
Okay, Ms. Kane, please proceed. Sorry, I'm a little tongue-tied.
Thank you, Chairman Gillette and Commissioner Karen and Commissioner Bedkowski. Thank you. I'm sorry we are pulling together in person to use this authority's valuable time and our valuable time, but appreciate the session to share our perspectives. First, we take the authority's good intentions for customers very seriously. And under this authority's guidance, we've demonstrated a commitment to consistently and proactively providing our customers with the best programs and protections available. At the same time, we've highly valued how the authority has sought diverse perspectives, considered and supported many of our innovative ideas in this space that we've brought forward and delivered on. On February 1, 2023, PURA issued a notice violation to CLMP and Yankee Gas. The NOV imposes a penalty of $100,000 to each company for a total of $200,000 for Eversource. Because the penalties are assessed individually to each company, although the companies share the single medical portal for our customers, for our medical professionals, the penalties are doubled for each infraction. For context, we thought it would be helpful for this broader group to be aware of that the medical portal is for medical professionals only and not for customer use. It is also used across our 3 states. So receipt of this NOV has been very demoralizing for our employees who work tirelessly and with good faith efforts to be in compliance with PURA's hundreds of directives in this area in recent years and consistently go above and beyond to think of new ways to help our customers. Our employees are dedicated, caring, diligent, and hardworking, and receiving a possible penalty of $200,000 for minor edits and wording on our medical portal is counterproductive to our efforts, extremely stressful, and it's counterproductive to our efforts to best serve our customers. So I wanted to summarize, bring forward attention to the following 4 points. First, the NOV assesses a total penalty of $120,000 because the terms physician and medical provider were allegedly listed on the Eversource medical portal as the only entities able to complete medical certifications. The NOV states that we should have clarified that both physicians and APRNs may complete medical certifications. However, Eversource did not use the term medical provider on the Eversource medical portal. This is a mistake in the NOV. We use the term medical professional, which aligns with the Connecticut law. Effective October 1, 2021, in General Statute 16262 CB1 and 16-262 DB. Please let me know if I'm going too fast. Oh, no, there's no more. Okay. Were modified to include physician's assistants as medical professionals eligible to complete a medical certification for a customer. The term physician's assistant was not included in Pura's language. By comparison, the term medical professional encompasses all three types of medical professionals that are required by statute, including physicians, physician's assistants, and APRNs. If we'd followed Pura's language guidance, we would have excluded physician's assistants, which is contrary to the law. On the second NOV, which assesses a penalty of $20,000 for an alleged failure to use the word residential in conjunction with households, to clarify that medical protection extends only to residential customers and their households in the medical portal fact sheet. Specifically at page 4 of the NOV asserts that Eversource violated order number 22 of the final decision by failing to clarify that medical protection extends only to residential customers in their household, as directed in section 2D3 of the final decision. However, order number 22 does not reference section 2D3. Order number 22 does say that Eversource shall finalize the medical portal fact sheet in accordance with the EOE attachment included in EOE's July 1, 2021, order number 10, compliance in docket 17-1203 REO1. We followed the EOE attachment as directed. However, EOE's attachment did not reference the word residential. So in this area, again, we feel the NOV is mistaken. Third, the NOV assesses a total penalty of $20,000 for an alleged failure to provide customers with hyperlinks to the Eversource medical portal that are searchable through the Eversource's customer website search function. To clarify, the medical portal is not a customer-facing web service, and therefore providing customers with a searchable term on the main page of the website isn't necessary, and it's not detrimental to the medical certification process. The medical portal is searchable through all search engines, including Bing and Google. And the medical web portal and medical portal is exclusively used by those professionals. In addition, it is discoverable, as I mentioned, by those search engines. Fourth, the NOV assesses a total penalty of $40,000 in which Pura alleges a failure to remove disclosure language on the medical web portal and medical certification form, indicating that physicians must complete the form under penalty of perjury as directed in section 2D3 of the final decision. However, Eversource removed any reference to a form of penalty for medical professionals in 2020, as noted by Pura in its interim decision in docket 17-1203 REO1, dated December 2nd, 2020 at page 20. So again, we believe this NOV is mistaken. When a notice of violation is issued from minor edits or wording errors, 5 months after the company has submitted a compliance filing in this matter, it creates a high stress working environment for employees. Instead, these types of working differences should be worked out with a call or notification to the company to make changes in the most timely manner. We're completely dedicated to our customers and simply seek use of our employee resources in an efficient, productive manner to that end. We hope that Pura will see fit to make that a reality by forgoing these penalties and allowing a more collaborative compliance environment going forward. And that concludes my opening statement.
Is your client available for cross?
Yes.
All right, thank you. Does the authority staff have any cross at this time? No, thank you. Who is up next? Does the Office of Consumer Counsel have any cross?
No cross there, thank you.
Thank you, Mr. Vice Chairman.
Just a quick question, Ms. Kane. Thank you for your testimony this morning. You said in your remarks this morning that you used the same portal in New Hampshire and Massachusetts. Do you have any, and I should know this, I'm sorry, any NLV violations in those states?
We do not.
Now, the other thing is, have any of the providers, people that utilize this form or consumers complained about it?
We
Complained about any of the language that was in there?
We have no complaints from medical professionals or customers complaining about the language on the portal. Period.
Thank you.
Thank you. Ms. Kane, I think it was point 1 when you were discussing medical professional and that terminology to be consistent with state law. Did the company submit a motion for clarification or a motion for change to the authority's decision with that matter? If because I took it from your statement that you believed that what you were doing, you seem to concede that you knew you weren't doing what the authority ordered, but that you thought what you were doing was better. So did you seek a motion for clarification or some change to the authority's directive?
Thank you, Chairman Gillette, for that question. To clarify, the company believed that the authority's orders were not requesting us to not comply with the statute. And we also knew that of the 47 of the 55 orders that applied to Eversource, most of those also applied to our partners at Avangrid. So in reading through those, for example, with medical provider, we knew we didn't have that word and we had medical professional. So reasonably, we thought it was not intended to apply to us because it would make it inconsistent with the law.
Okay, I appreciate that answer, but just to be very clear, you did not submit a motion for clarification.
We did not submit a motion for clarification.
Okay, thank you. And then with respect to the date of issuance of this decision to the date that the notice of violation was issued, are you aware of how much time transpired? The decision, I believe, that we're talking about was April 20th, 2022.
So April 20th, 2022 is the decision, and to bridge to which state?
To the notice of violation issuance.
In February.
Okay. So is the 210701 and the record that gave rise to the decision issued in April of 2022 the first time that we've discussed issues with respect to the medical hardship customer portal and materials?
Believe that I believe EOE's report from the prior year's annual energy affordability proceeding explored a number of topics. It did not explore these topics as far as actionable takeaways in that report.
In 171203 RE01, one of the sprints was not focused on medical hardship customers or issues in communicating with them.
Sorry, to clarify, the EOE report that came out of that 2021 proceeding, there was a material discussion in that proceeding, and it did not recommend the changes that are reflected in the authority's final decision on this docket.
Understood. I'm asking a slightly different question, although I think we got there in that answer. My question is, in the past 4 years, is the only time that we've discussed issues with the company's communications with medical hardship customers in that docket 220701, or have we discussed the company's communications with medical hardship customers and medical providers and other dockets besides 220701?
I think that across multiple dockets, many dockets, the authority has discussed communication with customers. In this docket, this is related to communication with medical providers.
Mm-hmm. Okay. So one of the sprints in 171203 RE01 discussed medical providers and communications with them? I'm phrasing that as a question.
Do you want to share?
Yes, I believe in docket 17-1203 REO 1 during the medical sprint, there was discussions around the medical portal and training doctors, medical professionals to utilize the medical web portal.
Okay, so thank you. Does the panel recall what may have given rise to the identification of that sprint as an issue? I just want to clarify, just a few moments ago, you represented to the vice chairman that there were no complaints or issues with respect to the medical portal, which does not comport with my recollection of how we got to where we got. So I just want to make sure that we're clarifying the record. And if your answer was you haven't received any since the portal was updated and pursuant to 210701, that's one thing. But do you recall what gave rise to this as a topic in the sprints?
I do have so as far as what gave rise to it in the sprints, I know a number of sprints were started at the same time. So medical provider feedback for ease of use. That is what 17-1203 REO1's report from EOE on July 1, 2021 provided.
Mm-hmm.
And those recommendations did not touch the ones that we are in this proceeding today for. So, for example, on page 3 of the EOE report, it summarizes the different recommendations that EOE had, adding branding for the companies, including patient consent language, updating.
I'm sorry, I think I understand where you're going. I was just trying to clarify when you say that didn't give rise to the recommendations. I'm not asking, I apologize. Let me ask this in a different way. We've had a number of dockets, as you alluded to, 17-1203 REO1. We've had affordability dockets each year, including docket number 180425, in which there was a survey done that we had lots of discussions about. And unless my recollection is completely faulty, I recall numerous complaints in 180425 survey with respect to interactions with the medical providers. I mean, certainly something gave rise to us identifying this as a topic for a sprint. I wouldn't have, made it up 4 months onto the job here. So I'm just trying to make sure that we have a clear record, because a few moments ago you indicated that there were no complaints, and I don't think that comports with my recollections. I'm just wondering if you want to clarify.
Maybe take a moment.
And can I just ask a clarifying question? I want to make sure the witness can be responsive. I understood the thrust of the chairwoman's question and also the vice chair's question to be, were there any complaints regarding the ability of a medical professional and or their support staff to be able to utilize the medical portal? I just want to clarify, is that the thrust of the question being offered to Ms. Kane?
That is not my question. No, my question is, were there complaints that gave rise to us identifying the need to address medical hardship customer communications and portal and interactions with medical providers?
If we could take a minute just to consult, going back a few years on that. How do I push?
You need to.
Could they have a moment, please, Chairman?
Sure, just turn off your microphones, please. Ms. Washington?
Yeah, so I'll help respond to that. So going back to 1804-25, and I do recall there was the survey that was completed for many medical professionals or societies in that docket. And as you were saying, what gave rise probably to the energy affordability track 3 sprint that's on this. And if I recall from the survey, and I know it's probably been a while since I've seen that, but I remember some responses about defining life-threatening versus serious illness. I remember or recall the ability for like the medical portal, I think it was like a save and go if you come back to it. Renewal, like an auto renewal, I think, if somebody has a chronic illness year after year. So I think there was probably a number of things that was provided as feedback. I don't think I would categorize it as a complaint, but I think that probably helped give rise to the track 3, and then EOE or Pro at the time was tasked with putting together like a stakeholder feedback group.
Okay, thank you.
And sorry, to clarify, we didn't have any medical professional complaints leading up to that. Survey feedback when we're asking for what we could do better is different than a complaint on what you could improve.
Oh,
I think that's what the authority's question was. Did we have complaints versus feedback when we asked for it and what we could do better?
okay.
I do believe there was stakeholder feedback, other stakeholder feedback, but not from medical professional or customer complaints that likely inspired the start of that track. That's different than a customer complaint or medical professional complaint.
Okay. So when the company receives feedback from organizations that are representing customers, be it OCC, CCA, Operation Fuel, others, you distinguish the validity of that feedback from if you receive it directly from a customer. I'm just not sure what the.
To the contrary, it's different than a customer complaint or a medical professional complaint. Stakeholder feedback is different. We weren't making a statement of value in any way on stakeholder feedback. We're just, the question to the company was, were there customer complaints or medical professional complaints? And to that answer, there were none that we were aware of that drove that sprint.
Okay. So, late file exhibit, let's see. Bear with me a moment. Attorney Pace, I imagine where you're going. I would posit that I am impeaching the witness's testimony if I am guessing where you're going with this likely objection, but I would say I would refer the witnesses to late file exhibit 2 in docket 1804-25 and just, see if that refreshes anyone's recollection about whether there were complaints or not. So I saw, the corner of my eye was there.
If we could allow the witnesses an opportunity to be able to review the information and so that they can provide an informed response, as the chairman pointed out, it is a different docket. They did not review those materials in preparation for today's proceeding. And one question I just do have for my clients would be, do you even have a copy of the exhibit that the chairman's referring to?
I do not.
I do not.
Okay. Well then, I think that can speak for itself. And I'll leave that there. I don't believe there are any other questions at this time, so I'll ask if the company needs a moment for redirect.
I would please, and could I have permission just to please step outside and speak in the hall with my clients? I think I need about 5 minutes if I have permission to do that.
Absolutely. We'll take a 5-minute recess.
Thank you very much. Commissioners, thank you for giving me the latitude to consult with my clients, and I apologize for taking longer than 5 minutes. I respect your time, and I'm sorry that it took us a little bit longer. I do have questions for redirect examination for my clients. I'd like permission to proceed.
Please proceed.
Thank you. Ms. Kane, do you recall the colloquy earlier this morning between you and the chairman and the vice chairman where they asked you questions about complaints if the company has received any? Do you recall that exchange?
I do.
And regarding the specific violations alleged in the notice of violation, has any medical professional complained to the company saying they were not able to access the medical portal for the specific reasons identified in the notice of violation?
No.
Have APRNs been able to access the medical portal?
Yes.
Have physicians' assistants been able to access and use the medical portal?
Yes.
Have physicians been able to access and use the medical portal?
Yes.
And have the authorized administrative staff for physicians been able to access and utilize the medical portal?
Yes.
And in your view, are the allegations in the notice of violation comparatively minor when compared to the overall key goal of making sure that we have a functional medical portal that allows APRNs, physicians' assistants, physicians, and their respective authorized office staff to be able to communicate information regarding customers' medical conditions?
Yes.
Thank you. That completes my redirect examination. Thank you.
Thank you. In that case, we have reached the end of our agenda. The next steps in this docket include filing of briefs on or before July 11th. We are tentatively scheduled for a regular meeting September 6th. And I would advise that folks keep up to date on the external calendar for this docket to see if that date changes. But briefs are due July 11th. Are there any closing administrative matters before we adjourn this specific hearing? None? All right. Thank you to the witnesses for your testimony this morning, and we are adjourned.